Hello everybody and welcome to another Scuffed Radio video. So I've been seeing a lot on YouTube over the years of people that really have no clue about how the FCC operates and the legality of free speech on ham radio. So anytime free speech and ham radio comes up, you always get the same old arguments of, well, you can't talk about politics or religion, no obscene topics, and it says that in Part 97, right? And it says that in the ham exam. Okay, so that's true. It does say that in Part 97. It does say that you can't talk about certain things. However, we have case law that actually goes back to, when does it say? 1981, March 20th, 1981, or issued March 20th, 1981. This is kind of a bombshell sort of case where the FCC tried to suspend the license of somebody named David Hildebrand up in California. Over what he said on the amateur radio bands. He actually said some stuff on 2-meter on a repeater, and the stuff he said was fairly adult-themed, pretty extreme when it comes to adult-themed stuff, and he just said it out on the open airwaves, and somebody from within the FCC caught wind of it and tried to suspend his license and get his license taken away. And so here I'm going to kind of just briefly go over the actual document from the case here and kind of bring up some interesting points about why free speech and the First Amendment are protected on amateur radio, and why if you look up the FCC's history of enforcements, you will not find any kind of enforcements related to simply the speech that is done on amateur radio. You may find enforcement actions taken against jamming or purposeful interference, stuff like that, but you're not going to find stuff done purely based off the language used on radio. So here we have the case in PDF format, and we're going to kind of go through what I think the important parts of this are. If you want to read the full document, it's available on David Hildebrand's QRZ page, N6BHU. If you go look him up on QRZ, he's got the PDF file of this case linked there, and a little bit of backstory about this. But anyway, we're going to go over the case here. And I'm not a lawyer, but I can still interpret the important things from this and relay them on to you. So, one important thing here is that it mentions the Communication Act, that says the license may be revoked for willful or repeated violations of the Communications Act or communications rules. So, basically they're saying, look, we can take a license away if they continue to violate the rules, right? The second thing they say is they're going to try and determine whether the transmissions on January 24th, 1981 were a willful violation of Section 97.115 and or 97.119. So they're trying to determine whether or not he said stuff that violated Part 97. That's pretty easy to figure out, right? Here we have the transcript of what was supposedly said over the air. It's fairly long. This is just the first part of it, but it continues on down here. You can see that they're having a rather adult conversation with some rather adult topics being discussed here. You know, your average suburban mom would say, oh, it's so indecent and obscene, blah, blah, blah. And I'm not disputing that here. What was said here was pretty extreme. I mean, I don't have a problem with it. I think people should be able to say what they want. If I was listening to this, I would be probably listening intently because it would be very entertaining. But there's no denying that what he said here was very, very extreme, could be offensive, shocking, surprising to your average listener, all right? Anyway, let's go on past the transcript here. So here we have the point where they revoke the amateur license or attempt to revoke it and find him in violation of 97.119, which prohibits the transmission of obscene, indecent, or profane matter. There's no denying that that is exactly what he did. Now, everybody's definition of obscene, indecent, or profane is that's subject to personal opinion. So I can't even in confidence say that this was truly obscene or indecent. This was just shocking language to your average person, all right? The material facts are not in dispute, as you can see here. He engaged in exchange over amateur radio frequencies in which he used gutter parlance. There, see, boom. There is no dispute. If anybody tries to come up and say, oh, they didn't rule on whether you could actually use that language or not, no, this is the proof right here. There's no dispute whatsoever that what he did would be in violation of 97.119, right? Let's move on. So here's where things get interesting. The initial decision cited another case law where the government basically said that the general public has a right to be protected from unwelcome views and ideas into their homes. And at the time when this was made, radio and AM radio and FM radio, stuff like that, that was sort of the television of the time. I mean, you had TV, but radio was a big part of it. So if someone went on a public radio station and said a bunch of, crazy stuff, it would be heard by quite a bit of people, possibly unintentionally. People might leave the radio on, and they're just kind of using that as an example here to say that, listen, broadcasting on the open air is, forcibly putting gutter parlance into people's homes. So this is what this section, I think, in my opinion, is basically trying to say. And they also say that there are 66 amateur radio operators under 17 years of age licensed in the Los Angeles area. So they're saying, look, we've got young people. Won't somebody think of the children? Think of the children. There's people under 17 years of age, and there's 66 of them in Los Angeles. Which, that's just a more, Puritan busybody mentality. But anyway, that's what they're saying here. They're saying, look, the people have a right to be protected from this kind of speech, and there's young people in the area, right? Which is, I guess, a fairly normal argument to make. Here's the bombshell right here that proves that you can say whatever you want on amateur radio. As long as you are not bridging into other areas where it becomes a domestic issue, such as making threats. If you're threatening somebody's life, threatening to do them harm, it doesn't matter what medium you're on when you say those things. That's a whole other matter altogether. That's independent of ham radio. But when it comes to the language used and the subjects discussed, this right here proves that you can pretty much talk about whatever you want. So I'm going to read this here verbatim for the most part, and then I'll talk about it some more. We must disagree with that decision. The Commission has precisely defined and prescribed indecent matter in certain broadcast context. And it lists here another case. And specifically articulated its concerns in the unique area of broadcasting where the signals are available indiscriminately even to children of a very tender years. So they're like, yeah, young people can hear these transmissions. The Supreme Court narrowly affirmed the Commission's other case, ruling on that basis. So this other case that they're referring to, actually they're saying, well, it was narrowly confirmed simply because broadcast radio is available to a much wider and younger audience. Without such specific standards, proscriptions on speech may as well be stricken for vagueness. Here we go. You cannot put a rock-solid limit on what is considered profane or indecent or obscene. That's all down to personal decision-making. And you can say, well, let's just take the general population, let's just take the general public, let's, average it out and try to please as many people as possible. But I'm sorry, that's not the way the law works. You can't really do that. So this is what they're saying. Amateur radio is not broadcast. Therefore, the leg that they're using to stand on only applies to broadcast and not amateur radio. They list a couple more case laws here. See generally Miller versus California, blah, 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 where the transcripts proffered at hearings shown to be obscene within the established legal definition, a different result might here obtain. So it does not, again, apply to amateur radio or any kind of radio. They're saying, well, if what he said was, obscene under the more extreme legal definition, meaning just any kind of content, I guess is a word to use, content. If that was the case, then they would also be held under that umbrella, but they're not. This is just amateur radio. What he said was not extreme enough to fall into that category. And here we go. Here's another big important piece. The concept of indecent is intimately connected with the exposure of children to language that describes in terms patently offensive as measured by contemporary community standards for the broadcast medium. Sexual excretory activities and organs at times of day where it is reasonable risk that children may be in the audience. Emphasis added on the broadcast medium. I personally don't agree with what they're saying here, even for the broadcast medium. I think that, think of the children, somebody protect the children. I think that's a poor argument to make, no matter who you are, no matter where it is, no matter what's going on. Think of the children is a poor excuse, because that's what parents are for. If you're expecting the government to protect your children from offensive language, then you've failed as a parent. That's your job as a parent. But anyhow, they emphasize again, for the broadcast medium. So the government here, the court system here is saying that, yes, on broadcast, you can regulate free speech. You can regulate these sorts of things in the name of protecting the children, more or less. On amateur radio, amateur radio does not fall under these categories. It says right here, amateur communications are not a form of broadcasting and are not transmitted to the public at large. Boom. That's all you need to know right there. Amateur communications are not a form of broadcast and are not transmitted to the public at large. Therefore, none of the FCC's attempts to regulate what you can say on the air are ever going to have an effect. I don't know why they leave these things on the books. I know it's a lot harder to get rid of laws than it is to bring them in, but I think it's just there because, well, who's going to remove it? Part 97.119 isn't going to leave because it would just take too much trouble to remove it out of the books. You know how laws just hang around after they're long since been obsolete. They stick around because the way our government works is just messed up. But anyway, this page right here is all you really need to know when it comes to, is free speech allowed on ham radio, and can you get away with it / is it acceptable? So this page proves everything. If you have anybody telling you can't say this, can't say that on the radio, they're wrong, and you can. Now, in these modern times, we have so few places that are not censored and not controlled and not regulated and not have scrutiny about what you say, that I think radio, the purest form of communication that we have, wirelessly at least, I think that analog radio should be a very important place that should be on the forefront of maintaining the First Amendment rights of every citizen. If you're a private repeater owner and you're shutting down the repeater or something because there's a topic being discussed that you don't like, you are part of the problem in this modern time we have of censorship and restrictions on speech, stuff like that. So I just want to make this little video here to prove to anybody who doesn't believe that free speech on amateur radio, and by extension CB radio, GMRS, FRS, all these other similar modes, you are never going to get in trouble simply for speaking about a topic on the radio. Now, our government is corrupt. They do stuff that goes against the Constitution all the time. So that's something else to keep in mind. You may end up with a overzealous FCC enforcement lawyer who just wants to make a point, and tries to go against you. But if they do, at the very least, you do have this case law to fall back on, which is a pretty definitive decision here. And that's backed up by almost 50 years at this point of existing FCC enforcements where they have not gone after anybody else just for speech. They go after people for jamming, especially when it's related to public safety or commercial operation. Yes, they do go after jamming. That's as far as it goes, though. Speech on its own is not a focus for them. Anyways, guys, hope this video was enlightening, informative. Hope you learned something. Thank you all for watching. Bye.